Imagine you're playing a card game where each dealer gets to interpret the rules slightly differently. Some favor aggressive play, others reward caution. Wouldn't you try to play at tables with dealers whose style benefits your strategy? In the complex world of litigation, attorneys make similar calculations in a practice known as judge shopping. When major cases challenging government policies appear in certain federal districts with remarkable consistency, it's rarely a coincidence. Litigants on all sides of the political spectrum, from civil rights advocates to corporate interests, from environmental groups to state attorneys general, have strategically selected venues to improve their odds of a favorable ruling. This calculated approach to litigation reflects a pragmatic truth. In American courts, judicial philosophy matters. Legal outcomes often depend not just on precedent and statute, but on who interprets them. But where is the line between strategic advocacy and undermining judicial neutrality? At its core, judge shopping refers to the various tactics litigants use to increase their chances of having their case heard by a specific judge they believe will be favorable to their position. This practice exists on a spectrum, from choosing plaintiff-friendly jurisdictions, forum shopping, to more targeted strategies aimed at landing before a specific judge within a particular court. These tactics take various forms. Some litigants file in districts with favorable judicial philosophies. Others exploit divisional assignment systems, where cases filed in certain courthouse divisions are automatically assigned to the only judge serving there. In some instances, parties might file multiple similar cases, dismissing those assigned to less favorable judges. Throughout American history, judge shopping has influenced landmark cases. In the civil rights era, the NAACP carefully selected venues for desegregation lawsuits. The Eastern District of Texas became a hub for patent litigation in the early 2000s, while the Southern District of Florida, Western District of Louisiana, and Northern District of Texas have emerged as popular venues for challenging federal policies. In these districts, litigants can often predict with near certainty which judge will hear their case. The debate over judge shopping encompasses compelling arguments on both sides. Critics contend that judge shopping undermines judicial impartiality and the rule of law. When cases appear predetermined by which judge is selected rather than legal reasoning, public confidence in courts may diminish. The practice can also create inefficiencies when similar cases are filed before different judges, potentially leading to conflicting rulings and complex appeals. However, defenders argue that judge shopping is simply zealous advocacy, attorneys using every legal means available to advance their clients' interests. After all, lawyers have ethical obligations to represent clients diligently, which may include filing in the most advantageous venue. Courts and Congress have implemented various reforms to address concerns about judge shopping. Random assignment systems, specialized courts for certain case types, and restrictions on venue transfers all aim to limit the practice. The federal rules of civil procedure restrict dismissing and refiling cases, while many districts have adopted rules specifically targeting division-based judge shopping. In 2023, the Judicial Conference approved policy changes requiring federal courts to use random case assignment among all judges within a district, though implementation remains ongoing. Understanding judge shopping offers valuable insights into how procedural rules interact with substantive outcomes. It reveals the tension between formal legal principles and the practical realities of litigation, raising fundamental questions about our judicial system. When does strategic venue selection cross into improper manipulation? How do we balance geographic access to courts against potential forum exploitation? Should judges' known perspectives be considered legitimate factors in litigation strategy or threats to judicial neutrality? These questions have no single correct answer, but they highlight a central paradox in American jurisprudence. While we aspire to a system where the law's application doesn't depend on who applies it, judicial identity and philosophy inevitably influence outcomes.